Hey, serious question. Did you?
I didn't read all the way. I went up to 17.
Oh my God, you actually read.
I read, but I didn't finish it.
I did not. I'm gonna go first case.
I did not finish it. So, I was reading, and then until we got the syllabus, and then I stopped because I thought.
But it goes to up to like 527 to 5. Don't worry.
He said 5 something.
I just didn't get to it on time. I was like sleeping the whole day.
Where is everybody?
Daniel's here. I think just went to the bathroom.
You didn't have to share that.
He took a break.
A little too much information.
And then Isabel's here. She's off.
She's not gonna be for the next 15 minutes.
So. Is Trish plugged in online? She wasn't saying the
I admire you for your efforts.
What pages do you see in the interview?
527 all the way to like pretty much the last page for the next reading. So 527 through 578.
527. See, I went up to 574.
What's me for? Nice.
I didn't finish it.
No, you got this.
That's all I have to say about this.
No.
You see, I saw an email and I was just like, no.
I know, it's a good thing I started reading beforehand because if I would have got that, I was at work. I couldn't.
What time
Oh,
is
no,
it?
you. I was at work too. I didn't see it until I got out.
I started this like 2 weeks ago.
Oh, you did?
Oh, you
Yeah,
did this
'cause-
reading?
Oh.
Yeah, because.
Damn.
You're the only one that did the reading.
We didn't get the syllabus yet, so I was started reading because I'm so slow. I
Oh,
started
good job. That was good. Yeah, that was really good.
Okay, so you have a question? Give them to George and when he's finished, and do the hot tonight. All right.
Bless you.
It's really cute.
These are. I see.
Isabel's gonna be here in a few minutes.
Yeah. I don't know what's going on here. Doesn't make any sense.
You guys have it? Well, yeah, like every Saturday. Oh, that's right. Oh.
I think.
All right,
Well, we didn't have four though.
here's the essay question. I sent you guys I emailed you this afternoon with a copy of the question and model answer.
This one? This one fits in. That was it.
That's Trish's.
Everybody have it? You got your own, you've got your answers, right?
Yeah.
And my nasty comments. Okay. Who's number 18? Is that Trish? Nobody in here. Trish, can you hear me? Trish? Hello? Can you hear me? No? No, can't hear? What's going on?
Sorry, no, I can hear you. I'm sorry.
All right. So is your number 518? What's your number? Student number?
I don't know. I think it's 201 at the end. Hold on, I took a picture of it yesterday, I think.
Oh, no, 201. I'm sorry, 201.
201.
Yeah.
201.
All right. Got it.
Okay.
Just a minute. Be back in a minute.
So how are we gonna drop this truth bomb? What is it?
Well, the thing is, it's not the one two is reading. Like, he was week two is reading, I'd be like, okay, we should have done that.
We should have asked at least.
But
It's not.
you just need to practice it.
Okay, Trish, we're going over exams.
Okay.
And so I'm getting them to email you your essay and your MBE answers.
Okay, thank you.
Okay. Has everybody, except for Trish, gone over the essays? Some people are still reading. Okay. Raise your hand when you're done.
Raise your hand when you're done.
I know you're done, but the others.
There is a problem with the syllabus.
I know. I emailed you about it today.
I just saw it.
You didn't read the chapter?
Nope. I did not. It's not even on the syllabus. syllabus, that reading. I'm being serious.
Well, we'll just have to deal with it. Maybe, let's finish this.
I'm done.
You done? You done? Trish, you can read your essay, the comments on your essay later.
Sure, no problem.
Okay, so,
Yep.
turn those in. Well, actually, no, you gotta turn those in. Those are scans of the originals, and I did it by email this time. Okay. So let's do, here are your scantrons. I don't know who to do.
Yes. That's it.
No, these are my names.
Oh,
Yeah.
So, did anybody do better on this one, on your multiple choice than you did before? Was what we did helpful?
Yes.
Yeah.
How much better did you do?
Significantly.
A lot? Okay. But let's go through them anyway. And did anybody read the chapter today?
I did,
You're the only one.
but only.
All right, well, then you're gonna brief all the
I'll
cases.
brief all the cases, except for the last one. I didn't do the last one.
I'll do most of them. I'll let you do one.
Okay.
How's that?
That's fine.
We'll just do straight lecture and I'll brief all the cases. This particular chapter, you're not gonna get any essay questions on anything that's in it.
Okay.
Okay, the topics in this chapter, resolution before trial, until you get to motion for summary judgment. And then between now and the end of the year, all of your essay questions will probably have a motion for summary judgment. Okay, I mean, motion for summary judgments in probably 50% of the civil procedure bar exam questions. But resolution without trial is basically a basket full of stuff about how to get rid of the case. Okay, and that you'll find is loaded for multiple choice questions because they can just say, basically, what's the difference between a default and a voluntary dismissal? And then you're given 5 different potential answers, okay? Or a default judgment does the following, and all right? That's the kind of stuff you're gonna find in this chapter. So if you haven't read the pages that I sent you today, it will be good if you read them, okay? In the future, if you have a syllabus like this one, and you go to the pages that I put in the syllabus, and you see that it was something that you already read from last semester that you've already been tested on, and it doesn't go with the chapter number, send me an email, okay? Because something got screwed up here. I don't know what happened.
Well, you had sent one and then Irene sent a revised one, so I thought,
Maybe the revised one got the wrong page. I don't know what happened.
They were both the same. I checked to make sure, but we should have emailed you regardless.
Yeah, you should have let me know.
Yeah.
Because I don't have anybody to, proofread my garbage. All right, I mean, it's nice if you have a second set of eyes to at least look at it. All Irene did was she stuck, that this was syllabus number 2, basically, and one other thing. But nobody checked out to see whether or not I had all the right pages, although I was sure I did. And what those may have been is somehow that was a leftover from the previous book that I didn't catch. I don't know, that probably is. At any rate, I can go through this stuff after we're done with this. We'll either get done with this and do the break, or we'll start on this and then do the break, okay? So Daniel, we start with question number 34. Now just like we did the last time, just go down the line, okay?
In Ashcroft versus Iqbal, the Supreme Court ruled that plaintiff's complaint contained insufficient detail. Choose the answer that best describes the court's ruling. A, the court based its decision on Rule 9b. B, the court carefully limited its ruling to complex cases likely to create elaborate discovery. C, the court's decision was consistent with a long line of pleading cases under the rule. Or D, none of the above. I chose D.
And D is right.
35. An award of punitive damages will likely violate due process if they exceed A, 9 times the compensatory damages, B, 5 times the compensatory damages, C, 3 times the compensatory damages, or D, due process has nothing to do with punitive damages. I put A, and that was the correct answer, 9 times.
9, yeah, that's right. 36.
36, defendant receives a summons and complaint issued by federal district court. But the summons and complaint is a request for waiver of service of process. Which of the following is accurate? A, if defendant signs a waiver, he cannot thereafter make a Rule 12b2 motion. B, if defendant signs the waiver, he has 60 days in which to answer the complaint. C, if defendant does not sign the waiver, he will have a default judgment entered against him. And D, if defendant signs the waiver, he will be responsible for the costs of serving him the process. I chose B.
You chose what?
I chose letter B for Brian,
Yeah.
and that is the right answer.
Did you choose B because that's your name is Brian?
No, I knew, I knew that was the right answer. I thought you were.
All right.
Let me clarify.
All right, Clara.
Plaintiff files a complaint, defendant answers denying liability, and the case proceeds. After the close of discovery at the time of the judgment has set for such motions, defendant files a motion for summary judgment arguing that the complaint is barred by the statute of limitations. On the merits, D has a strong case. P argues, however, that because the statute of limitations was not specifically stated as an affirmative defense in D's answer, it was waived. Which is the best answer? A, the affirmative defense was waived. B, the affirmative defense is waived unless D, for justifiable reasons, is permitted to amend his answer to include the affirmative defense. C, the affirmative defense was not waived, or D, none of the above. Well, I got that one wrong.
You didn't have to tell us.
Oh. I put D, none of the above, but it's supposed
I
to
mean,
be.
B is like a really good answer. I mean,
I know,
not
and
not
they
only
all
does it
look- say
that the affirmative defense is waived, but it goes on to say unless da. Okay? Trish,
I haven't received the questions yet.
you haven't? Did you get anything?
No. Unless
Well,
something's weird with,
Oh,
Hold
oh,
on.
you-
unless something is weird with my, can you hear me?
Yeah, we can hear you.
Yeah,
Yeah, no, I haven't gotten anything yet.
Okay. So, so just have fun listening, I guess.
I will.
Okay, 38.
Paul sues a manufacturer, retailer in federal district court. The complaint alleges that P was injured because of a defect in an appliance. Manufacturer believes that the appliance was not defective when delivered to retailer and that any defect must have been introduced when retailer was in possession of that appliance. Manufacturer should A, file a 12B6 motion, B, file an answer alleging as an affirmative defense that it was really retailer's fault, C, deny the allegations of any defect caused by manufacturer and wait for discovery, D, move under 12C to strike the allegation of the defect. I chose C as in Charlie, and that was the correct answer.
The American rule, A, requires all parties to pay their own attorney fees. B, requires that the loser pays your attorney fees. C is the same as the English rule unless there is an exception. Or D, requires all parties to pay their own attorney fees unless prevailing party attorney fees are allowed by statute or contract. The answer is D.
40, Paul sues Dennis on an unpaid promissory note. Dennis answers a complaint with a denial of breach and pleads to allegations labeled affirmative defenses. That the 1 year statute of limitations is run, and 2, that he failed to repay the debt because he needed the funds to pay for medical care for a sick child. Paul's lawyer determines that neither affirmative defense is valid. 1, the applicable statute of limitations on a promissory note in writing, as this one is 4 years, and 2, the law of contracts does not recognize the second defense. Paula's lawyer should A, apply for an injunction requiring Dennis to make his answer, B, file a Rule 12F motion to strike the 2 affirmative defenses, C, file a Rule 12C motion for judgment on the pleadings, D, file a Rule 12B6 motion. The correct answer is C.
Is what?
C.
C, what? What did you say?
The correct answer is C. Oh, I'm sorry. B, I thought it was.
B,
I don't know why I said the wrong number.
B.
Yes, B is right.
Now, what happens if you file a motion to strike and it's granted?
Strike it.
He's got 2 defenses. And it's a motion to strike both defenses. And there's no defense. Then what would you do?
So do they render judgment against it?
Then you'd file a motion for judgment on the pleadings. There's no defense.
Okay.
Either that or a motion for summary judgment, but why would you go through a motion for summary judgment? All that rigmarole you're gonna find out about next week. Okay. If you do a motion on the pleading, it was, look, on the complaint, there's, on the answer, there's a complaint and there's basically an answer with no defenses. Okay? We win. Get it? All right, let's go. Next.
41, so Hotel Inc. agreed to a construction contract with Prime Inc. to build a hospital in Houston, Texas. Prime contracted with Planners Company and architectural firm, and Dirt Inc., an engineering firm hired to do soil testing. Because the completed facility has been sinking into the ground, Hotels has sued Prime for breach of contract and fraud, asserting allegations that Prime defrauded Hotels by intentionally inflating cost of the project in taking kickbacks from one or more of Prime's subcontractors. If Prime moves to dismiss, what result? Well, the correct answer, okay. A is, the motion should be denied because the complaint contains sufficient factual details for Prime to answer and raise defenses. B, the motion should be granted because the complaint does not allege knowledge specifically. C, the motion should be granted because the complaint does not contain sufficient details of the fraud. Or D, the motion should be denied because it does not appear beyond doubt that hotels can prove no state of fact entitling it to recover for fraud. So the correct answer is C.
Okay. You still don't have anything, Trish?
No, I do. I'm just trying to open it right now.
Okay, well, we'll keep going. We'll get you next round.
All right.
Okay.
42, beginning in January of 2008, Bitsy Boxer began feeding her dogs broken bone dog food. While Bitsy did not notice any problems initially, about a year later, her dogs stopped eating the dog food, and Bitsy believed there was something defective with the product. On November 19, 2010, Bitsy filed suit in federal court against BBD Inc., the maker of the dog food, serving process on the president, Martin Mastiff, alleging the dog food was low in calcium, therefore causing certain defects and abnormalities in the dogs. Asserting a claim for breach of warranty, Bitsy asked for damages in the amount of $100,000. BBD filed and served its answer on December 1st, 2010. In the answer, BBD initially admitted the food was low in calcium, but low calcium does not cause the symptoms alleged in the complaint. However, after BBD's expert, Dr. Hund, reported that low calcium...
Hund.
Dr. Hund.
Hund. Like, that's German for hound.
No. I don't speak German. Reported that low calcium can cause such symptoms, BBD sought to amend its answer to deny the food was low in calcium. Under these circumstances, A, the judge might allow the amendment. B, the judge should allow the amendment because it could have been done as a matter of course. C, the judge should deny the amendment because parties are not allowed to change their factual contentions. D, the judge should allow the amendment because prejudice to Bitsy is unlikely, but BBD should be sure its denial is warranted on the evidence. The correct answer is D, but I chose A.
It's, this one's, anyway, yeah. He's right, but kind of like the playoff game in New Orleans.
Okay, 43. Bitsy also needs a pleading amendment because her lawyer inadvertently omitted a claim for the recovery of consequential damages. Assume the court is favorably disposed toward allowing Bitsy's proposed amendment. Bitsy has an additional problem. The statute of limitations on any claim against BBD ran out on January 21st, 2011. Thus, Bitsy's claims would be barred unless the amendment relates back to the filing of the original complaint. Should the amendment, if allowed, relate back? A, note, the consequential damages claim does not arise out of the same conduct, transaction, or occurrence as Bitsy's original claim for damages. B, yes, because BBD had timely notice before the statute of limitations ran, and because consequential damages do arise out of the same conduct, transaction, or occurrence as Bitsy's original claim for damages. C, no, because BBD should not be surprised by future amendments. And D, yes, because there would likely be no prejudice to BBD if Bitsy added a further claim. And the answer was B.
44.
Unless otherwise specified in the FRCP, after being served with a complaint, the defendant must ordinarily file her first responsive pleading, A, within 21 days, B, within 14 days, C, not before expiration of the safe harbor period, and D, within 30 days. The correct answer is A, within 21 days.
In a lawsuit brought in federal district court, a complaint and an answer have been filed. If the case follows a typical pattern, which of the following discovery events would occur first? A, exchange of expert witnesses. B, planning conference. C, interrogatories. D, Rule 26A1 disclosures. And I got it right, planning conferences, B. I'm excited, I got it. B.
You got it right?
I got it right, I'm excited.
Is that the only one you got right?
Yeah. Pretty much.
Okay. Your turn. Trish?
Yeah, I'm sorry. I'm just having issues. I'm sorry. Can I get me next round?
Yeah, what's going on?
Well, I'm opening it. Oh, here we go. Here we go. What number is it again?
46.
86?
46.
46.
46.
The heck? Okay, hold on. Damn it. Here we go. I got it.
A motion to strike.
I got it. Okay, here we go.
You got it or not?
No.
All right, let's go.
All right, is it my turn?
Yeah.
46. A motion to strike under Rule 12F. A must be made within 14 days of being served the complaint if the complaint fails to state a claim. B must be made within 14 days of being served the complaint if the defendant seeks to remove redundant, immaterial, impertinent, or scandalous matter from the plea. C must be made within 21 days of being served the complaint if the defendant seeks to remove
Redundant.
21, yeah, the only difference is 21 and 14. I thought I was reading the same exact thing. Or D must be made within 21 days of being served the complaint if the complaint fails to state a claim. The answer is C.
A motion under Rule 12B6 attacks the complaint. A, for lack of subject matter jurisdiction. B, for failing to state a claim upon which relief can be granted. C, for lack of personal jurisdiction. D, to remove redundant, immaterial, impertinent, or scandalous matter from the pleading, and it was B, failing to state a claim.
What did you say?
C, failure to state a claim.
Okay. 48. A motion under Rule 12B must be timely filed or offenses are
Wait a minute, I want to go back. 47.
Yes.
Did anybody get that wrong? That's the one question nobody should get wrong. Okay. 48.
48. A motion under Rule 12B must be timely filed or the offenses are forever waived. Which defense is never waived? A, personal jurisdiction. B, subject matter jurisdiction. C, insufficient process. And D, defenses under Rule 12B cannot be waived. And the answer is B, subject matter jurisdiction.
I take it back. Nobody should get that wrong either.
Yeah.
Okay. Next.
49, under Rule 8, a complaint must contain a short statement regarding the grounds of the court's jurisdiction, a short and plain statement of the claim showing the pleader is entitlement to relief, and a demand for relief.
You don't have to go further.
Okay.
Say,
It's a
these are like throwaway questions. Okay,
She get it.
50. Trish,
I got it.
are you with
Okay.
us?
I am.
50.
50. Under Rule 11B as in boy, where a defendant believes the complaint contains wholly unfounded and frivolous claims, unsupported by any applicable theory of law, a defendant may seek the imposition of monetary sanctions against the plaintiff and the plaintiff's counsel by A, waiting the applicable 21-day safe harbor period and then file her answer raising Rule 11 as an affirmative defense. B, serving the opposing counsel party a copy of the proposed motion for sanctions described. Offending language that violates Rule 11B, waiting 14 days, and if the offending pleading is not withdrawn. I don't have my answer sheet right there because it's on another thing, but I'm going to say It was
It's D.
D. That's what I was gonna say.
D is in David.
D is in David.
Serving the opposing counsel party a copy of the proposed motion for sanctions describing the offending language that violates Rule 11B. Waiting 21 days, and if the offending pleading does not withdraw or corrected, file the motion with the court. That's safe harbor. 51, let's just go to the correct answer. Does everybody have the correct answer?
Yeah.
Trish, you should have the correct answer too.
I do. I'll find it.
Do you have your answer sheet?
Yeah, it's just Yeah, I've done another one.
To get to it.
Well, we'll just keep reading and you can just listen to us.
I'll follow along. Okay.
Yeah, let's just do the correct answer and move this along. Counsel.
Okay, counsel. So you want me to read the question, but just.
Where are we? 51, right?
51. Yeah, okay. Barbara brings a diversity action against Donald in federal district court seeking damages for breach of contract. Barbara has documents which she believes support her position, as well as a witness, Ethan, a former employee, and a document that will make it harder for her to prevail on her claim. Which of the following statements is not true? B, in her initial disclosure, Barbara need not reveal that Ethan or the unhelpful document, but she must reveal them if she is subsequently sent an interrogatory asking her to identify any relevant document or witness.
Excellent. Let's go to Barbara versus Donald, 52.
The Barbara v. Donald lawsuit continues. Donald, having learned through interrogatories the identity of Ethan, subpoenas him to appear at a deposition. If in the deposition, Donald's lawyer asks Ethan about his sexual history, which is irrelevant to the lawsuit, A, Ethan's lawyer can object on grounds of irrelevance, and if Ethan's lawyer so objects, Donald cannot ask Ethan to answer the question.
Okay. Still Barbara v. Donald. Through interrogatories, Donald learns that Barbara's in-house chief financial officer, a certified public accountant, may have relevant information about such matters as damages suffered by Barbara. Which of the following statements are accurate? They stated that's either C or D. So C, Donald can depose the CFO whether or not Barbara plans to call him as a witness. And D, even if Barbara plans to call the CFO as a witness, he need not prepare an elaborate Rule 26A2B report.
What was the answer to that?
Huh?
It was D?
C and
Either C or D.
Oh, okay.
Or you could have done both. I don't think anybody would have done that. Okay, but okay, 54.
Okay, 54, more Barbara versus Donald. Donald has his own problems with discovery. One, when he learned that Barbara was contemplating a lawsuit, he ordered an employee to shred some relevant documents.
That might be a problem.
2, he failed during initial disclosures to produce a document that he used as an exhibit in Barbara's deposition. 3, he failed to appear at his properly noticed deposition. 4, when he did finally appear to be deposed, he repeatedly gave evasive and incomplete answers. 5, in response to a request for documents, he failed to produce the document in question on the erroneous ground that it was irrelevant. As to each of these actions, Barbara wished to obtain the requested information and to seek sanctions if they are available. Identify which of these statements are true. And I put D, but they circled C and D. So C, as to 3, Barbara can expect that a minimum she would receive the fees and costs attributable to Donald's failure to appear. And D, as to 4 and 5, Barbara must first seek a ruling ordering Donald to comply with the request before seeking any sanctions.
Okay. You understand?
Yeah, I didn't know if she could get the minimum fees and costs.
Well, you have to seek it with a ruling. Okay. 55.
The obligation to preserve evidence arises, C, once the party has noticed that the evidence is relevant to litigation, or when a party should have known that the evidence may be relevant to future litigation.
Which means it can arise before the lawsuit is filed. 56.
Spoliation is I was gonna start reading them all. Yeah, it was C. Spoliation is the destruction or significant alteration of evidence or the failure to preserve property for another's use as evidence in pending or reasonably foreseeable litigation.
57.
7. Paul was injured while operating in drill press manufactured by Manco. Paul properly commenced an action against Manco in the appropriate U.S. District Court. Prior to trial, Paul sought discovery of a report which had been made to Manco by Brown, a claims investigator for Manco. Brown had inspected the machine and investigated the circumstances of the accident immediately thereafter. The machine was subsequently destroyed in a fire, and Brown has retired, leaving no forwarding address. Paul's request for Brown's report should be B, granted even if prepared in anticipation of litigation of trial, provided Paul can show that there is a substantial need for the information he needs, otherwise unable to obtain it without undue hardship.
The language of the statute. 58.
58, P sued amusement company for injuries sustained when she fell while getting off a Ferris wheel at the amusement company's park. The lock holding the seat had prematurely broken open. At P's suggestion, her boyfriend immediately took pictures of the broken lock. Since the park was still open, amusement company hired a locksmith to replace the lock that same afternoon. In doing the work, the locksmith had to completely disassemble the broken lock. P's attorney hired an expert locksmith to prepare a report and testify at trial regarding the defective nature of the lock. Amusement company moved to discover the report prepared by P and the pictures taken by P's boyfriend of the broken lock. P claims both the pictures and the report are covered by the work product privilege. Which of the following statement is correct? And it's C, amusement company may view the pictures but probably not view the report before trial, because ordinarily the opinions of an expert prepared in anticipation of trial can be obtained through
Interrogatory.
P sues D for trespass at her Los Angeles residence. The action was properly commenced in a U.S. District Court. D defends by claiming that he was in New York at the time when the incident allegedly took place. D intends to call Wanda as a witness to testify that she saw him in New York on the day in question. He believes Wanda is hopelessly nearsighted and could easily have mistaken someone else for D. In order to impeach Wanda's testimony, P sends Wanda a notice to appear before a licensed ophthalmologist selected by P. Which of the following statements is correct? C, Wanda need not appear because she is not a party to the action.
Anybody not understand that? 60.
If a party fails to respond to written discovery requests, the remedy is D, file a motion to compel responses and seek sanctions.
61.
Dawn, while traveling to a nearby relative's house, is injured by a vehicle which was negligently operated by an Acme employee who was using his car for an Acme business purpose. After initiating an action in the proper federal court against Acme, Dawn seeks pretrial discovery of the insurance policy covering the Acme vehicle. Which of the following are correct regarding discovery of the insurance policy covering the Acme vehicle? 61 is, the answer is C. Discovery of an insurance policy may be obtained where the insurer may be liable for all or part of a judgment entered against the insured.
62.
Andy Attorney is a new associate at a prestigious downtown LA law firm. He is working on a major federal securities fraud case in the Central District of U.S. Federal Court. Andy has noticed and taken many depositions in the case, but is now confronted with the following allegations. 1, Andy's examination of a witness was solely designed to embarrass, annoy, and harass the opponent. 2, Andy and his client failed to
No,
attend.
what's the correct answer?
Well, it says, okay, so would be A down
Yes.
here.
Andy's examination of a witness was solely designed to embarrass and harass the opponent. 63.
Attorney Clark had been retained to defend WDN Corporation, an international microchip kingpin, in a federal antitrust action commenced by plaintiff, a corporation, in the appropriate U.S. District Court. After Clark served a request for production of a large volume of documents from plaintiff advised Clark that it objected to Clark's discovery request on the following grounds. 1, the documents sought are privileged. 2, the information is factual in nature and relates to the plaintiff's claims. 3, the documents sought were not reasonably calculated to lead to the discovery of admissible evidence. 4, the evidence sought is obtainable from a less expensive source, which the foregoing objections might be valid. And the answer is A, 1 and 3.
Okay, we gotta go back and do 62 again. I misread it.
I have
Clara?
to read it again?
Yeah, read it again. We never got past 1.
Okay. Okay, so, should I start with 1?
Yeah, no, it's Andy's attorney. We gotta do the whole damn
Okay.
thing over.
Andy Attorney is a new associate at a prestige downtown LA law firm. He is working on a major federal securities fraud case in the Central District of U.S. Federal Court. Andy has noticed and taken many depositions in the case, but is now confronted with the following allegations. 1, Andy's examination of a witness was solely designed to embarrass, annoy, and harass the deponent. 2, Andy and his client failed to attend the deposition of Andy's client, which was properly scheduled by opposing counsel. 3, although a party who was deposed by Andy was not represented by counsel, Andy nevertheless insisted upon carrying out the deposition. 4, Andy objected to almost every question asked his client at a deposition, and all answers were made subject to Andy's objections. Which of the foregoing assertions could result in sanctions against Andy and his client? And that would be A.
Okay,
1 only.
and Andy's a juror.
Yeah.
Okay. 64.
P filed an action against D Corporation for breach of contract and misrepresentation in the sale of a home located in a subdivision. An agent of D allegedly represented to P that the property was in excellent condition and ready for occupancy. But P found that 1, the plumbing was defective, and 2, there were termites in the basement. Prior to filing the action, P's attorney consulted with an economist concerning P's damages. B, the discovery of an expert is discoverable through interrogatories.
65, under Rule 26, the parties to the litigation must submit these voluntarily without being asked. B, initial disclosure.
And
Let's see for
66.
Okay. E, a state X corporation designed a building for Smith, a citizen of statewide, 6 years ago. Part of the building collapsed last year, causing damage of more than $80,000. Smith has filed an action against E in the U.S. District Court in State X, alleging that his damages resulted from the negligent design of the building. E filed an answer denying negligence and asserting as an affirmative defense that the statute of limitations for negligence is 2 years. At the time the building was being constructed, Jones, an attorney, a member of E's board of directors who occasionally handled legal matters for E, prepared and sent the following memorandum to the president of E. I have been informed by Tom Withers, an architect who used to work for E, that the materials being used by the contractor Building Corp in constructing the building are substandard. Smith sought Jones' memo in request for production of documents. E refused to produce the memo. Thereafter, Smith filed a timely motion to compel production of Jones' memorandum. If E asserts the work product privilege in response to Smith's motion for production of Jones' memorandum, It would be C, Smith should prevail because it is relevant to his action unless Jones can demonstrate the memo was sent as legal advice and not just as a concerned board member.
There you go. So, would you guys, we have your papers.
Thank you. These two are both CDE, and I think they have to be based on it. So you got my section, it's fine, so we did.
Wait, what? There are check marks next to them.
I know, but I think they thought they were nonsense with, it's 11, about those two. And I got them sticked after that.
I wouldn't check that, I should probably count them.
Should write it down. Yeah.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, yeah.
Cause these two. I think these two they counted as wrong. Even though they're not Tenant Veronica.
You want them to be counted as wrong? even
No,
though they-
she counted them as wrong, I think, and instead of the check, as in they were correct. So it's,
Well, then tell Veronica, but she's not here.
no,
Did you write it down?
no, I'll see her Monday.
Okay, no, I mean, did you write down what the two exam numbers, the question?
I think it's 53.
It's
You know the
53 and
number?
54, I'll make a note of it.
Every point counts, I guess.
Yeah.
I don't know. I do not compute the final grade. All right. So, let's get started. I'm gonna be cross-eyed by the time we're done. So, the first category, I'm gonna amend my suggestion. Instead of reading the chapter, if you got it, the outline, just read the outline and resolution of trial, resolution without trial, or whatever the title of the outline is. It'll be similar to this. Okay?
That outline that you're sending or what you sent?
Yeah, I'll take it back. I'm gonna send you an outline. Good, that's even better.
So what outline?
I was gonna suggest you read your own outlines, but I'm gonna send you a copy of this that won't have my briefs,
Okay.
Okay, that's good.
okay?
Yeah, thank you.
I get to keep my own briefs. Okay? So, first of all, we're gonna talk about defaults and dismissal. A default judgment is a judgment entered by the court when a defendant does not make an appearance and answer the complaint. Okay? The willingness to enter judgment against a party who fails to appear is a hallmark of modern procedure. However, judges are quick to set it aside. Why? Because it's a judgment on the merits. Okay? And the law favors adjudicating cases on their merits, not in default. Does that, what I said make sense? Okay? It acts as a judgment on the merits, but it's not. It's because somebody failed to do what they were supposed to do. So they want a case to go forward and be adjudicated on the merits, and that there be an actual judgment on the merits. We then have a case. How many cases you want to do?
I don't know.
Do you have any favorites?
No.
Well, I'll start out with this one. This is Peralta versus Heights Medical Center. This is a U.S. Supreme Court case on page 528. It was decided in 1988. The facts are that Texas law required that a party seeking to set aside a default demonstrate a meritorious defense. Okay, first of all, so this is what happens. Plaintiff files a complaint, right? And then usually what happens is a defendant just doesn't appear for some reason. There may have been a mistake in serving the defendant. Maybe they served the wrong person. They sent it, if it was serviced by mail, maybe they sent it to the wrong address and they never got service. Maybe they got service and they didn't know what to do because they didn't have a lawyer and they never got a lawyer. Or more often what happens, or as often as not what happens, is they hire a lawyer who has substance abuse issues or something and just fails to answer. Okay? So the plaintiff eventually goes to court, they file a motion for a default. Okay? Without going through ad nauseum all the things they have to do, the court enters the default. Then somehow the defendant gets notice of the default, usually because they've put a lien on their property or they've, taken their first month pay from their employer. Somehow they find out that there's a judgment against them and they had no knowledge that this judgment occurred. If they had an attorney, they get their attorney to go in there. The attorney usually falls on his sword and says, I screwed up. I was sick. My wife died, something. Okay. And the court usually will set it aside. Okay. Get it? Yeah. And you can expect that even though you're filing a motion to set it aside and the court grants it, you're gonna probably get assessed for attorney's fees for the other side. Okay, for having to file a motion to have it to file a default judgment motion, okay? So, and sometimes they'll oppose it, but it's kind of stupid to oppose it.
It seems fair.
Yeah, I mean, the smart thing to do is an attorney calls up the plaintiff's attorney, defense attorney calls up the plaintiff's attorney and says, look, I'm terribly sorry. I was overwhelmed, I had too much work, whatever it was, and I screwed up and I didn't file the answer on a timely basis. We're gonna file, unless, either way, we're gonna file a motion to set it aside. Would you stipulate to it being set aside? And most lawyers will say, sure. Because they know the judge, they should know that the judge is gonna set it aside. Okay, but there are plenty of jerks out there who will say no. If the attorney says no and opposes the motion to set it aside, and there's clearly good grounds for it, then he may not get attorney's fees. Okay? Anyway, that's the reality of how these defaults work. Okay? Now, here's the real world case in Peralta versus Heights Medical Center. Again, Texas law required that a party seeking to set aside a default demonstrate a meritorious defense. So under the Texas statute, if you want to set aside a default, it's not enough to set it aside because you screwed up and you're throwing yourself on your sword and seeking the mercy of the court. Okay, you also have to show that you have a meritorious defense. Does everybody understand that? That's what the law said. Okay, in this case, the medical center sued Peralta to recover $5,600 due under Peralta's guarantee of one of his employees' hospital debts. So Peralta was an employer, and Peralta's employee had a debt for medical treatment to the hospital of $5,600. Service was, and they're suing Peralta for the $5,600. They're suing the employer. Okay. Service was personal, but return of service showed that service was untimely. Peralta did not appear, needless to say, they didn't get timely notice. Default judgment was entered for the amount claimed, and attorney's fees and costs were levied against Peralta. The medical center sought and obtained a writ of attachment, and unbeknownst to Peralta, his real property was attached and sold at what he claimed was below market value. Okay, pretty serious stuff. Peralta filed a bill of review to set aside the default judgment, alleging untimely service and that he was not personally served. The medical center filed a motion for summary judgment, arguing that a party seeking to set aside a default judgment must demonstrate a meritorious defense. Peralta conceded he had no meritorious defense. The Texas courts ruled in favor of the medical center. The issue is the Texas law requirement that a party seeking to set aside a default demonstrate a meritorious defense a violation of due process? What do you think? In order for you to get a default set aside, you have to show that you have a meritorious defense. Is that a violation of due process? No. No. No.
I'll say no, but
Why? Because everybody else
I
said
say
no?
no, but I was trying to say
He's gonna
yes.
say yes.
I'm
Well,
saying
you were gonna
yes.
say yes?
I was gonna
Why are you gonna say yes?
Because it's a violation of his due process, so it wasn't served timely on him. Right?
Right? Well, that was a violation of due process.
Okay.
But is the Texas statute requiring that you show a meritorious defense before you can get a default set aside, a violation of due process? See, that's two different issues.
Okay,
3 no's.
okay.
You gotta take a position.
I gotta take a position. All right,
Which?
Go with your gut.
go with my gut.
Go with your
I'm
gut.
saying yes.
Okay.
Still saying yes.
Your gut was right. Your
My
gut's
gut was
right.
right.
Go with your gut. There you go. Okay. For the court, Justice White, Whizzer White. Anybody know why they call him Whizzer? Huh? He was All-American football player. They called him Whizzer White when he was playing football in college. I think it's for University of Michigan, but I'm not sure. Anyway, for any proceeding to be granted finality, due process requires notice reasonably calculated to apprise interested parties of the pendency of the action and afford them the opportunity to present their objection. Pretty much what you said, right? So due process, the issue is notice in civil procedure, right? He didn't receive notice. The court went on to say the judgment occurred without notice to appellant. Notice at a meaningful time and in a meaningful manner that would have given him an opportunity to be heard. So the judgment was reversed. Yes.
So it was reversed in the sense that he didn't have notice, but what about the meritorious defense?
They struck down the statute.
Oh,
They
okay.
said the statute was unconstitutional because it didn't provide someone who didn't receive notice, whose due process rights were violated, from getting a motion of getting a default judgment set aside, okay, on the basis that they didn't get notice. All right, so the whole statute fell. It was Texas. I mean, that's to be expected. Okay. So what do you think? Why provide Peralta as day of court if there was no defense?
Well, because of course, want judgment on the merits. Is that our initial discussion?
That sounds right. It's wrong, but that sounds good.
But wasn't this regarding the 14th Amendment and this due process, and that's why they brought it into court? As,
Well, if the guy didn't have a defense, they're saying, the question is, if the guy didn't have a defense, why provide him with a day in court?
Well, I guess because the Constitution says that we all have a right to share our story, I guess.
You still have a right to your day in court.
what was a constitutional issue?
Well, this is what White says. White said maybe he could have joined third parties who had, either who had a defense, like his employee. Could have brought his employee in, maybe his employee had a defense. The employer didn't have a defense. He's not the one who didn't pay it, right? Although he paid, that might be a good defense. But this guy said he didn't have a defense, so He said also, White also gave an example. He said, well, he could have sought an opportunity to have his property sold at fair market value. I don't know how that would have happened if the property was already sold, but this is his example. And then he went on to say, even insolvent debtors are entitled to their day in court. Okay? Whatever that means. Let's go to note 3 on page 531 and 532. Even if you haven't read it, you should be able to do this. Page 531, everybody got it? All right, let's start. There's sub D.
D as in dog.
D as in dog. Look at it. 2D. 2D. Okay. I will read the first sentence and then Daniel, you follow. All right.
Yes, sir.
The defendant is served and retains a lawyer who then fails to respond to the complaint or to court orders. All right, keep going.
Theoretically, it would be easy to enter a default judgment and let the plaintiff sue his negligent lawyer for malpractice. In practice, courts don't like that solution, in part because the same lawyers who fail to answer their complaint are unlikely to have bothered to buy malpractice insurance, or the problem can lie with the client rather than the lawyer. Consider Honda Power Equipment Manufacturing Inc. versus Woodhouse. This case arose from a patent dispute between Honda and Mr. Woodhouse, who claimed that some of Honda's engines infringed his patent. Honda filed a declaratory judgment action seeking a judgment of non-infringement. Woodhouse hired a lawyer who acknowledged service of process and requested additional time to answer. But Woodhouse then failed to respond to his counsel's inquiries, and an answer was never filed. The court entered default judgment, but only after writing a 6-page opinion reciting defendant's counsel's repeated efforts to get a response from his client, the prejudice to Honda from the delay, and the fact that the UK court had found against Woodhouse in related patent litigation.
Okay, keep going.
Honda's
Number 3.
willingness to grant Mr. Woodhouse an extension of time to answer in the preceding note is typical. Plaintiffs are often ready to grant such extensions, particularly if they think that the defendant will use that time to decide whether to make a settlement offer. Suppose you represent a defendant who comes to you with a complaint. Time is running. In the absence of an extension, how long do you have to file an answer?
Anybody? You?
21 days.
How many days?
Is it 90?
What?
I thought it was 20.
90? 90? How many?
What did you do?
How many days do you have?
21?
If no waiver of service. Right? If service is not waived, it's how many days?
21.
Okay. If service is waived, 60. Remember? Okay. B.
After discussing the case with your client, you call the plaintiff's attorney, with whom you've not previously dealt, and have a relatively cordial conversation in which she agrees to extend the time to answer for a month. Relieved, you hang up and turn to some other pressing work on your desk. What risk are you running, and what should you have done to avoid it? Well, it doesn't say that.
You just got off the phone. The person that you spoke to said, okay, you can have, I'll
And the
wait.
first thing you should do is note it on your calendar, but this guy didn't. And-
Note it on your calendar.
Yeah,
That ain't enough.
That's what's illegal.
Well, how?
You gotta confirm it in writing,
Oh, okay.
okay? Giselle here says, have the waiver in writing. Well, the opposing attorney isn't gonna write you a letter saying, I granted you a waiver, okay?
Right.
So what you do is you write them a letter, okay? Some people do it by email. I would do it by a formal letter. Okay, you can email them a letter. But the letter should say, this will, dear so-and-so, it was a pleasure talking to you this morning. This will confirm that you graciously granted my client a waiver and an extension of to such and such a date, okay? Thank you for your courtesy and cooperation. Yours very truly, and you sign it, and you can scan it and email it to them. And in the email, you can say this confirms your waiver, and here's a letter for your records. And then I'd send it off by US mail as well. And then you put that in your hard.
Certified mail?
Nah. I don't think you have to, if you send it by email, I don't think you need to do it by certified. Do you? I mean, as long as it's in writing and you send it by US mail, it wouldn't be, you could do certified.
Yeah.
Just to cover your ass. I mean, what is it, $6 or $7? Yeah, it doesn't have to be return receipt. You can just be certified. And then you just stick it in your file. And unless they write back and say, I did not, then it should be a done deal. Because you can attach that to any court motions as evidence, and any court will accept that. Okay? You have to have a declaration under penalty of perjury attaching it. Okay? Everybody understand that part? If you look at Rule 55C and 60B, you read them together, they mean that a default acts as or constitutes an admission of liability. Okay? Now, what happens after the court enters a default, if it's not set aside, is that's a finding of liability. Then there's a prove-up, what's called a prove-up, where the plaintiff will file a second motion attaching by declaration and whatever documents, evidence showing what their damages are. And then the court will invariably, if the defendant doesn't appear, fine for the plaintiff and then enter a judgment or whatever the plaintiff seeks. But even if the court doesn't grant the motion to set aside the default, the defendant can still appear and dispute the damage, the prove up. All right. So that gets us to involuntary dismissals. We'll do that after the break.
No, I have enough.
Oh, you like the sexual. Okay. We always, those are always interesting.
How is she, Eric?
She's quite now. She put it into the notice from that company.
Oh,
okay,
okay,
so she
she just quitting.
The company wanted to go back to that case. It's like, dude, 3 times. It's like, put
Do you
it-
still want her to go back to the same?
yeah, because they're like, oh, they honestly don't. I don't know. They're like taking advantage of it the wrong way. Taking advantage of someone.
Oh, those new
Well,
issues.
no, but I had it for a year or so. I only ran when it's cold. Or when
They're
it's like
cute. Well,
11 clerks.
they're manly.
Oh man, I don't care. The girls are cute. I need to look good on me.
Yeah.
Right, ladies? Okay.
Am
Anyways,
I right?
yeah. I love the Clarks. I put them away. Only wear them when it's type of weather's right. Like a lot of my clothes. So you guys chose the jury? today?
Yeah, we
Yeah.
chose a jury today.
Okay. That's amazing. I was actually applying to firms outside of the valley as well, so I'm like, I don't mind the drive. I just can't stand like.
Did
no.
you see the one from Nolan? The
Yeah.
one about the job offer?
Yeah, I applied to that one too.
Did you apply for that
Yeah,
one?
I got an
Okay.
interview next month,
Oh, good.
so I need to brush up on the firm and stuff. It's typical paralegal legal assistant work, obviously, tough draft stuff, research. So, hopefully you don't ask for high standards.
No, that's okay,
I don't
because
work.
that way it's, get you familiar. in the legal world.
Yeah. Surprisingly, I think I've like driven by there many times, like after just delivering the routes. I'm pretty sure I saw that. The building before.
March Madness, or- no, not March Madness.
No, man, UCLA's playing, but they're terrible.
Dude.
The Lakers are even worse.
Oh.
Well, until we get our starting lineup back in,
Yeah.
we're dead. Okay,
This weekend, is it?
we're now gonna do, what are called, what is involuntary dismissals and, voluntary dismissal. An involuntary dismissal under Rule 41B is a dismissal on the defendant's motion. A court may order an involuntary dismissal against a plaintiff for failure to prosecute, to comply with the rules, or to comply with a court order. In other words, under 41B, it's different than a default. It's because after the plaintiff has answered, after the plaintiff has appeared, whether they answer or do anything else, the plaintiff screws up. Okay? Notice, failure to prosecute. What often will happen is that a plaintiff has a lousy case, not in the sense perhaps that they can't prove it, but it's very low damages. And the lawyer doesn't want to do anything because his fee's not going to be very much, okay? So he just kind of sits on it and hopes that he can just wait until it comes up for a trial date and that there's a mandatory settlement conference, and he goes to a settlement conference and lo and behold, he's going to get a settlement. Or maybe it'll go to mediation. We'll talk about mediation in a minute. And we'll just settle it at mediation, okay? And time goes by and time goes by and he doesn't do anything. Okay, he doesn't serve any discovery, he doesn't notice any depositions, he doesn't do anything. And finally, the defendant files a motion to dismiss for failure to prosecute, or the judge, more often the judge's clerk, notices that this guy hasn't done anything for 2 years. This case has just been sitting there gathering dust. And so the court on its own motion can dismiss it, or the plaintiff does all these evasive, unethical things that we were reading about in the MBEs earlier today. Right? He ignores court orders, doesn't show up at depositions, file a motion to dismiss under Rule 41B. They also can use the scheduling order in federal court and failure to prosecute. The scheduling order can do to the plaintiff what time to answer does to the defendant. It provides deadlines. If the plaintiff fails to meet the deadlines, dismissal threatens. There are two differences from default. First of all, the standard for invoking it is fuzzier. You know, you have to figure out when is too long, when not doing something, when the plaintiff's not doing something is too long. And second, it can be raised by the judge, not just the defendant. Okay? And go on to Rule 41A, which is voluntary dismissals. In a voluntary dismissal, the plaintiff can dismiss his own case voluntarily, either with or without leave of court. If the plaintiff dismisses the case without leave of court, you know what I mean by without leave of court? You don't file a motion, you just dismiss it. Okay? Leave of court means without a motion and the court granting a motion. If the defendant has not answered or filed a motion for summary judgment, the plaintiff may dismiss her case by filing notice of dismissal. A dismissal by notice, a voluntary dismissal by notice, is without prejudice. Everybody understand the difference between with prejudice and without prejudice? Brian? You have a puzzled look on
It's a little
your face.
fuzzy. Can you describe it?
Okay. Without prejudice means that you can bring the lawsuit again.
Okay.
Okay, you can dismiss it, but you can refile it. Okay?
Right.
With prejudice means just what it sounds like. Okay? Like in a movie when somebody hires an assassin and they hire somebody to terminate somebody with extreme prejudice. It's a dismissal with prejudice. Okay? Get it? Yeah. Okay. Go back again. A plaintiff may dismiss by filing a notice of dismissal. It's without prejudice unless the plaintiff previously dismissed a federal or state action on the same grounds. Okay? That's called the two dismissal rule, which is if a plaintiff previously dismissed a state or federal action on the same claim, the second dismissal is with prejudice. Okay? The parties may stipulate to a voluntary dismissal, which is without prejudice unless the stipulation says otherwise. The plaintiff does not pay costs unless plaintiff files the action again after the dismissal. Okay? Now, if the motion for dismissal is filed with leave of court, which means not just on, what a notice dismissal means is you just fill out a form. Okay, there's a court form for dismissing a case. And you can file, everything can be filed online now. Okay, so you just file it online and the system will send notice to everybody, but you're supposed to send notice as well. Okay, so you send notice of the dismissal. That's a notice dismissal, a notice voluntary dismissal without leave of court. Okay? Now, with leave of court, that means you file a motion to dismiss. Okay? When a voluntary dismissal is not available, then you got to file a motion to dismiss. Where a motion to dismiss is not available is in situations like the defendant has answered. Once the defendant is answered, if you want to dismiss your case, you have to file a motion in federal court dismissing the case. Okay? Not so in state court, but we'll get there later. Not so in California state court. Also, if a motion has been filed, defendant's answered, and either side files a motion, okay, or defendant hasn't answered, they just file a motion to dismiss or any other kind of motion, you cannot file a motion, you cannot file a voluntary dismissal without first filing a motion for the court to grant leave to amend. To leave to dismiss, okay? Or if there's a previous dismissal. So if you've dismissed it once voluntarily without leave of court, second time you're gonna have to file a motion. That kind of a dismissal, if the court grants the motion to dismiss, is without prejudice unless the court says it's with prejudice. Okay, so in either event, on a voluntary dismissal, they're without prejudice unless otherwise provided. Okay?
So the court's the only one that can put with prejudice?
No, you could stipulate that it's with prejudice. If it's pursuant to a stipulation between the parties that it's with prejudice. Maybe the defendant talks the plaintiff into doing it with prejudice because he says, I'm going to take you to court and seek attorney's fees and costs. If you don't, who knows? All right. Now, Isabel.
Yes.
Let's go to page 535. Go to note 2 on page 535. Okay.
Rule 41A1A1 allows the plaintiff voluntarily to dismiss at any time before the defendant has answered. After that point, the court's permission or agreement of the other side is necessary. In one notorious case, the availability of voluntary dismissal proved catastrophic for the defendant. In corporate control litigation between Texaco and
Texaco versus Pennzoil.
Texaco and Pennzoil, Texaco Inc., v. Pennzoil. The plaintiff filed originally in a Delaware state court seeking a preliminary injunction. Defendant opposed the injunction but did not answer the complaint. When the court denied the request for a preliminary injunction, using language suggesting the plaintiff would eventually lose on the merits, the plaintiff quickly took a voluntary dismissal and refiled in Texas. A Texas jury eventually awarded the plaintiff $10 billion. Voluntary dismissal without court approval would have been unavailable had Texaco answered the Delaware complaint. The defendant's failure to answer has been described as one of the most expensive tactical errors ever committed in a lawsuit. Timothy felt.
That's enough. Get the point?
Yeah.
I remember this lawsuit. It was all over TV.
Yeah, all they had to do is answer the complaint. They never would have been hit with $10 billion.
And that's 2 walls at the border.
You think they filed a motion, you think they?
Double layer.
Had to.
All right. So now let's go to avoiding adjudication by settlement and ADR. Does anybody know what ADR means?
Alternate dispute resolution.
That's right. Alternate or alternative dispute resolution. Okay. Before we go to ADR, let's talk about contracting for confidentiality or confidentiality clause, otherwise known as lately in the media, NDAs, non-disclosure agreements. Okay. In California and in most states and in federal court, lawyers who know what they're talking about refer to them as contracting for confidentiality or confidentiality clauses, and we ask for confidentiality clauses in agreements. Okay. I never heard of an NDA until recently. Maybe in television, the television industry, they're all filing what they call NDAs, and now they just talk about NDAs like everybody knows what an NDA is. Anyway, we got a case called Kalanauskas versus Wong. It's out of Nevada. It's a 1993 case on page 550. And Clara is going to tell us about that. Before you get going, the general rule is confidentiality clauses in settlement agreements are enforceable. Okay? So it's done all the time. In fact, it's not unusual when you're in a mediation or you're discussing settlement for the defendant, especially if the defendant's a corporation or a well-known person, to ask for an institution, you know, to ask for a confidentiality agreement. We'll get to the scope of confidentiality clauses and how far they go later. Clara, you want to tell us about Kalanauskas?
Kalanauskas, okay. I'm glad you said, I didn't know how to pronounce her name. So the plaintiff is a former employee of Caesars, and she sued
Caesars Palace.
Caesars Palace Hotel and Casino. So, and she sued Caesars for sexual discrimination. So So, as part of the discovery, the plaintiff seeks to depose a Donna Thomas. She was another former employee who filed sexual harassment against Caesars the year before. And, Mrs. Thomas's suit was settled without a trial by a confidential settlement agreement. And there was a stipulation for a protective order, provided that the plaintiff Thomas would not discuss any aspects of the employment at Caesars other than to state the dates of her employment and her job title. So, okay, so there was a motion for protective order filed by defendant who was Desert Palace. They were doing business at Caesar's Palace. And they filed this motion for protective order because they didn't want.
They wanted to prevent the deposition.
Right. They didn't want her.
Talking.
Right.
They didn't want her to talk.
They didn't want her to talk. They didn't want anything.
Okay, so what's the issue?
I put down is discovery of a confidential settlement agreement private even when it would benefit a party by resolving disputes relatively quickly.
I've got, does a confidentiality agreement apply to discovery,
Okay.
not only of the terms and conditions of the settlement, but the factual circumstances surrounding the lawsuit? Okay? Now remember, this settlement agreement is similar to like the Stormy Daniels, what they refer to as an NDA, where she's not supposed to talk about anything, right? Can't talk about anything. Not that there was a relationship, what happened, as part of the relationship, that there was a settlement or the amount of the settlement. Okay? And that's basically what this is. They're saying not only can you not talk, it says here, in addition to not talking about the settlement, she shall not discuss any aspect of her employment at Caesars other than to say the date of her employment and her job. That's it. Okay? So what was the rule that you got out of this case?
I got Rule 26B1 that said parties may obtain discovery regarding any matter that's not privileged, which is relevant to the subject matter involved in the pending action.
Well, okay. That's a federal rule that the court cited as part of its ruling. But when I ask you for what's the rule of a case, all of these cases interpret a rule, okay? And the rule of the cases is different than the federal rule that gave rise to the lawsuit. So when I ask for what's the rule of the case, I'm asking for what's the interpretation that the court gave to that rule. So yeah, everything relevant is discoverable, okay? But what about a confidential settlement agreement? Is a confidential settlement agreement not relevant pursuant to the rule? And if so, why? And if not, why? What do you got?
Well, I put down for the confidential settlement agreement, it imposes penalties on Mrs. Thomas if she spoke or discussing her past employment at Caesars.
You know?
So that was kind of like, do they really want to impose that on her?
Okay. But remember, the issue of the case is, does the confidentiality agreement apply to discovery? And if so, not only to the terms and conditions of the settlement, but to the facts and circumstances surrounding the lawsuit. In other words, can you use confidentiality clause or confidentiality agreement to keep out more than just the terms of the settlement?
Oh, I see.
Would you, okay, I'll
I see
take it.
what you got, yeah.
All right, so the answer is the confidentiality agreement or a confidentiality agreement and a confidentiality order. If the court orders that the confidentiality agreement becomes a judgment, which usually is what happens, to protect against disclosure to third parties unless extraordinary circumstances exist. It applies to discovery of the specific terms of the settlement. For example, the amount and conditions of the agreement, and not to factual information surrounding the settling of the plaintiff's case. In this particular case, the court went on to say that preventing the deposition of Thomas would condone, quote, the binding of silence of a witness with a settlement agreement, end of quote. Court went on to say the public policy precludes such a result. The deposition of Thomas is likely to lead to relevant evidence. The settlement agreement itself makes exception for court-ordered release of information. But regardless of that, the court went on to say this court will allow the deposition of Thomas. So the conclusion was the deposition was allowed. The deposition and any further discovery into the Thomas Caesar's case must not disclose the terms and conditions of the case, but she can talk about how she was sexually harassed. Okay, get it? Notice in the Stormy Daniels case, they dismissed it. They voluntarily dismissed it. Okay, they got attorney's fees because Stormy's attorney filed a bogus defamation lawsuit against Trump. That's where the attorney's fees and costs came from. And what's his name? Can't even think of it anymore. Huh?
Cohen?
No, Cohen was Trump's attorney.
Oh, you're talking Stormy.
Hmm?
You were asking Stormy Daniels.
Stormy's attorney filed he filed a defamation case against Trump and Cohen, basically saying that because Trump said that it isn't true, it's a lie, that, you know, the usual, that was defamation. And the judge ruled that as being hyperbole of a litigant. And so the judge threw out the defamation case and then granted attorney's fees to Trump for, I think $300,000 in attorney's fees, thereabouts, to Trump, not on the case that Trump filed, but on the bullshit defamation case. So if Stormy's attorney had played it by the book and just answered the complaint and filed, you know, an answer with appropriate defenses and prevailed on that, they would get their attorney's fees and costs. But because he went an extra step and filed a bogus lawsuit against Trump for defamation, I mean, how can you get, assuming for the sake of argument that what a litigant says about a lawsuit is defamation, they're lying, okay? And it's all lying, it's all made up, and it's all fabricated, that's defamation. Did you get to that portion of the tort of defamation? New York Times versus Sullivan? Okay, Stormy Daniels, what's she? Huh? It's a public figure, so to speak. Pardon the pun. So, I mean, there's clearly no defamation. It was something, that he was doing to get on television. And I'm sure that he wound up paying it. Stormy didn't pay it. You haven't heard a word since, have you? Yeah, that was bad lawyering. It was great for him for a while, but that was stupid. Anyway, should have just played it by the book. Just answer the complaint. You can still appear on television. Anyway, so let's go to ADR. Alternative Dispute Resolution. Did anybody see the email I sent you guys today? There's an exemplar mediation brief,
Oh, yeah.
okay? Now, let me tell you a little bit about mediation. Under 28 USC section 651 and 652, in federal court, mediation involves the use of a neutral to assist the parties to a dispute, to reach a mutually acceptable agreement to settle the case. Okay? And that's what ADR is in state court. Mediation is mediation. Okay? The mediator does not decide who wins or loses. Rather, the neutral, a mediator is a neutral, is a facilitator who assists the parties to reach a settlement. In federal court, mediation is accomplished through local district rules. Local rules may make mediation mandatory by order of a district court. In the central district here, which is Los Angeles, Riverside, San Bernardino, and Orange County. Okay. Mediation is generally mandatory. In almost every case, the court orders mediation. If the court orders mediation, usually the court will order the parties to select a mediator from a list of what are referred to as panel mediators. Okay? In federal court, for a mediator to be on that panel, he or she has to file an application, and the application is fairly extensive. And I believe that it requires that you be in practice for at least 10 years and that you are certified to mediate, which means that you've taken at least 40 hours of mediation training. Most people take a training certification to become a certified mediator. They take a training course at Pepperdine Law School. Pepperdine Law School has probably the best mediation department in the country. Okay. And almost everybody in Southern California who's a certified mediator, who's a lawyer, has taken that program. There are other programs too. You can do it at the Riverside Superior Court. They have training. the LA Superior Court and Orange County courts have training, but that's Superior Court. In federal court, there's no training given by the federal courts. They assume that, they don't assume, they require that you receive training probably through Pepperdine. They don't say Pepperdine, but almost everybody that's on that panel has done Pepperdine. I'm on the panel. You have to have references from at least 2 judges, you know, a whole bunch of lawyers, and then there's a committee who decides. In most superior courts, they also have panels, but the requirements are less stringent. More like a warm body. To be on the panel, okay? There's a difference between being on the panel and then having the judges select you to do a mediation. So being on the panel is just somebody that the parties can select on their own. Okay? I got a call today from some law firm in San Diego asking me if I would do a civil rights case. 80% of the cases in the Central District are civil rights cases that are mediated. So I got a call today, you know, saying, would you serve on this case? It involves civil rights case against San Bernardino Sheriff's Department. And I asked a few questions. I don't like them.
He looks right at me.
Huh?
Don't blame me, don't blame me.
No, it has nothing to do, it's just I don't like, I'm not happy with their claims people.
Well, that's
That's
San
different.
Bernardino and I'm clean, so.
Huh? No, I'm just,
Clara?
I know.
it's just, it's not a big deal.
Mhm.
It's just, I shouldn't say I don't like them. I really don't want to drive to San Bernardino.
It's a.
They want to do it in their offices in San Bernardino. They don't want to go out to, they don't want to drive out to Rancho Mirage. It's too far. They don't want to go to Riverside, you know, and do it at the courthouse. It's too far. They want me to do it in their offices, that kind of stuff. So I'm thinking to myself, do I really want to do this? And then she said, you know, and I asked a few questions about what kind of case is it, and it's a bullshit case. I said, you know, are there any injuries? And she said, no. I said, so it's emotional distress? And she said, yeah. And I said, and so already this case, it's a nothing case. All right. You know that just going into it. And they ain't going to pay anything. They're not going to offer anything for emotional distress. You want emotional distress damages, you're going to have to go to trial. You know, that's what they're going to say. I know these guys. So I'm thinking to myself, do I want to drive all the way to San Bernardino? The first 3 hours are free. You only get your hourly rate after the first 3 hours. Well, on something like this, it ain't going to go 3 hours. So I'm going to have to drive to San Bernardino and do this thing for nothing.
Is it the first 3 hours leaving?
No, you don't get travel time. It's the first 3 hours of mediation. Okay. So she said, so what's your hourly rate? I said, I jacked my hourly rate way up. And I said, I'm fine. You know, you guys want to pay me my hourly rate after 3 hours? That's fine. I'll be there. And she said, well, you know, we're just checking out all the mediators. Okay, that's how the panel works if they do it voluntarily. Usually what happens is the judge will say, to the parties. Either you pick somebody or the ADR office will assign this case for mediation. Okay? And the ADR office knows the various mediators and who they are and who handles certain kinds of cases and usually who settles them, okay? Based on the type of cases involved. And, you know, they probably received complaints from some of the county offices about some mediators. I wouldn't be surprised if San Bernardino complained about me. Because as part of my process in mediation, if I think that they're full of shit, I'll tell them. Maybe not in those terms. But if I think that they're, you know, if I think they're gonna lose a case and they're gonna have to pay some money, I'm gonna tell them. And, you know, you guys ought to pay this guy some money. Get rid of it.
But they're bankrupt, so they don't.
Doesn't matter. Oh, no, they say that they're not bankrupt. That's the city, not the county.
That's what they said. Oh,
They say not the county, it's the city.
oh.
They say they got money.
The story changes.
They say they got money. They say they just don't want to pay it. No, so I've done a couple of mediations for them and I told them what I thought. Haven't had any since. So anyway, so that's how it works. Okay, the court will assign a mediator from the panel. Okay, in both federal court and state court, first 3 hours are free. In Riverside, there's a program, the Riverside Superior Court, there's a program called the First Friday program. Why they call it the First Friday, I don't know. But on Fridays before the trial date, which is on a Monday. So the Friday before the trial date, they have a trial call where all the attorneys show up with their parties and someone in authority. And they make their appearances and the judge will decide whether or not that case should be mediated. And usually there are 6 mediators that the ADR department there calls, and we're sitting there. And then we go into chambers with the judge after the calendar call, and the judge will say, who wants this case? Who wants that case? And we take the cases and try to mediate them. The last one was on the first week in January. I'm doing the first Fridays of every month. I showed up the first Friday in January, and Robert Evans was there representing one of his clients. And Robert Evans taught this class with me for the last 3 years. Okay, and he's there with his client, and he says, "What are you doing here?" And I said, "I'm a mediator." And he said, "Oh, are you going to mediate my case?" And I said, "Sure, I'd be glad to." Do you think that's a problem? Remember, I told you the mediator has to be neutral. Do you think knowing one of the lawyers is a problem?
Yeah.
I'm trying to facilitate a settlement.
Mhm.
I don't pick winners and losers.
Mm.
It's not a problem.
Mm.
I can know
Huh?
everybody. I can know everybody. Okay? mean, the whole idea is I'm trying to work with them. You could say that the mediator is a deal broker. Okay, like you go to buy a car, right? And instead of going to the dealer, you go through Cars Direct. Okay, Cars Direct is basically acting as a deal broker, isn't it? Or Costco. They're saying, well, you don't have to negotiate with the dealer. We'll do it for you and get you the best deal. Well, that's what a mediator's doing. And basically, in each session, when I go in with each group, I'm trying. In the case of the plaintiff, I'm trying to get them to come off of whatever it is that they're asking for. And for the defense, I'm asking the defense to come up with more money. Okay, and try to get them to the point where we reach a number that everybody can agree to. And then there may be some other terms, and we deal with the terms, and then we'll try to get to write up a settlement agreement right there on the spot. And then you take it into the court, and you give it to the court, and they put it on the record, case is done. Okay? Now, what we need in Washington with the shutdown thing and with everything else that's going on, we probably need a federal mediator's office that mediates between the sides, because these guys don't know how to negotiate. They're negotiating now. Tonight is the first night they started to negotiate. The rest of this stuff, all this stuff about, what Trump and Pelosi say on television, you don't negotiate on television. You negotiate in private, and everything's confidential. Why? So that you can get out what I want somebody eventually to tell me, what do you really want? All right? That usually takes hours, if not days. Because everybody's afraid to tell the mediator what it is that they really want, for fear that they're giving away too much.
They overcompensate at the beginning.
Oh, well, this is the story of negotiation.
It's want versus need,
It's-
I want this, I start out wanting this, and then they come down eventually to I need this.
But getting somebody to say this is what I need is like
Yeah.
it's a very difficult process. But the best example I can give you is, anybody here ever seen the process of buying a Persian rug?
No.
All right. So I'm in a Arab city in 1968 with somebody who spoke Arabic. And it's like one of these, Arab Kasbahs with, narrow streets and, a very atmospheric place. And I was looking for a dress for my girlfriend. And lo and behold, we get to this tiny, tiny little shop, and I see exactly the dress that I think would look great on. And I say to the person I'm with, let's go in there. I want to buy that dress. And we go in to the shop, and I ask the guy, how much is the dress? And this is all through the interpreter, the equivalent of $10. Well, even in 1968, $10 wasn't anything, right? So I pulled out whatever that currency was at the time, and I tendered the equivalent of $10 to this guy, and he starts screaming at me, "Get out!
get out. This is an insult. When we go outside, and I'm looking at this person, and I said, what the hell just happened? He said, you insulted him. So what do you mean I insulted him? He asked for $10. I gave him $10. He said, no. He says, you don't know how to negotiate. I said, what are you talking about negotiate? You go to a store, they ask, he said, no, not in the Middle East. He said, go in there and offer him $1. I said, $1? That's an insult. No, that's an insult. He said, trust me. Offer him $1. Okay? Okay, let's go in. I offered the guy $1. Guy goes running into the back of the shop, comes out 5 minutes later with a silver tray with a full tea service, silver tea service and cakes, right? And for the next 5 hours, I negotiated and haggled with this guy over this dress. And I finally bought the dress for $4. Okay? And he was happy as a clam. And the guy that I was with, who was telling me what to do, that's a mediator. That's what a mediator does. Okay? And that's exactly what the way those mediations go down. I just did a mediation on that January, first week in January. Not the one with Evans. That case would not settle. It went to trial the following week. It was just an auto accident. Okay. I can't tell you the name of the case or the terms of the settlement, but I think it started with the plaintiff asking for $250,000 and the defendant's offering $5,000. Okay. That sounds like an impossible situation, right? I mean, the gap is huge. It's I can't tell you for how much, okay? But it's and that's the job of the mediators, to get these two parties together. And, you know, usually people think, oh, well, they're going to meet in the middle. There's no way 250,000 and 5,000 are going to meet in the middle. Somebody's way off. Okay. And sometimes if you're dealing with insurance companies, a lot of times the insurance companies are insultingly low. Okay. You're nodding?
Yeah.
Yeah. I mean, just insultingly low. Sorry.
Getting bashed today.
What's true? They're cheap bastards. They are.
It's true.
I know. That's what I do. That's my job.
But not always. But not always. And often the plaintiffs are like in the stratosphere. You know, and a lot of these PI cases, they're in the stratosphere.
It's true.
And so it's, you know, it's up to the mediator to work with both sides and try and get them.
My guess is $20,000 would settle that.
That's usually,
I can't say.
That's usually the way workers' comp is. You do real low and somebody real high. But sometimes you have people that they don't know how to value a case.
That's right.
Like, oh, shoot. You know?
That's right. And you know, if you're dealing with good claims people, then they usually have the case evaluated properly in terms of what it's probably worth.
Mm-hmm.
But they don't come in close to that. Okay. And You don't do mediations in comp.
Yeah, we do,
You do?
we do.
Oh, I didn't know that there was mediation.
We do.
Oh.
Especially in contribution, like if there's other insurance
Okay,
carriers.
so, but usually the carrier, like if the carrier has the case evaluated at 50,000, they'll come in with an offer of 5 or 10.
Mhm.
And they will not reveal to me what they've really got. If they've got evaluated at 50, they've got authority up to 50. But they'll never tell me that, will you?
We won't.
No, they're gonna try and save every dollar, right?
Yes.
But if the mediator's good, he can read body language. They'll lie to your face. Right?
Yes.
They'll lie to your face, but if you know how to read body language, you know they're lying. Okay, and what they're lying about is either their wonderful defenses or how much they got. Okay, and you can tell just by looking at people usually when, you know, whether they've got more or not. You may not know what they've got, but you know they've got more. And with plaintiff's attorneys, if they're really good plaintiff's attorneys, then they'll come in with a lot of huffing and puffing and, you know, I'm gonna blow your house down, but I can deal with them easily too. It's the guys who don't know what they're doing that are the problem.
Like us.
No,
We don't know what we're doing.
no, I mean, no, there are people who have, you have no idea what I'm talking about. I mean, they don't research the law. They have little or no experience in the field of law that the case is all about. They haven't done any significant discovery or research to find, or investigation to find out what's really going on. And they're sitting there on, you know, some hyperinflated demand. And when you try, and it's difficult to explain to the lawyer that they're full of shit, okay, in front of their client. Because you're doing this in front of their client. And in order to get it done, they have to have confidence in you, and you can't make them look bad in front of their client. You know, you can't say, what the hell are you talking about? You can't say that. Why are you laughing?
That's funny.
I mean, it's just, you know, you can't say, you know, you can't say things like, well, you're an idiot.
You can't say let's go talk in my chambers.
Huh?
You can't say let's go talk in my chambers.
No. No, so, but it's fun. I mean, I enjoy it. Anyway, so let's talk about, that's mediation, okay? The only winners, the winners are both sides if you get a settlement. Okay? Most mediators will tell you that if somebody's happy after a mediation and you've settled the case, then you've probably done something wrong. Okay? Why are you smiling or laughing?
Because if they should be happy if you came to an agreement.
But usually the defense is paying more than they want to pay.
Right.
Okay?
And the plaintiff's taking less than.
And the plaintiff is taking significantly less than what they were asking for going in. Okay? So part of the dealing with the defense and getting them to pay more is not as difficult as explaining to a plaintiff who's probably never been in court before why this case that they've been expecting to retire on is probably not even worth a new car.
You know, that's probably worth a 5-year-old car.
A Pinto.
Maybe
A Pinto.
an exploding gas tank? Yeah, I mean, it's, you know, it's hard to because their attorney hasn't been saying, listen, yes, I took your case, but by the way, I took it, but it's a terrible case. You know, are you gonna say that to your client? No. So they expect the mediator to say, you've got a terrible case. And you gotta get it? Okay, so next is arbitration. There are two kinds of arbitration. There's contractual arbitration and there's court-ordered arbitration. Contractual arbitration is a written agreement to arbitrate a dispute which are considered to be valid and enforceable unless there's a contractual ground for revocation, like fraud, illegality, or unconscionability. The mechanism for appointing the arbitrators is usually included in the agreement. The court proceedings are stayed pending completion of the arbitration. The arbitration proceeding is usually similar to an adjudication. It's like a trial. You know, this would be a great place to do an arbitration because the arbitrator could sit up there and the parties could sit here and then everybody would feel like they got their day in court. Okay? Sometimes that's why you do arbitrations, is so that each side, and more importantly, the plaintiffs, feel like they got their day in court. The parties may conduct discovery and present witnesses and exhibits at a hearing. The arbitrator's decision is referred to as an award. The award can be for the plaintiff who receives X number of dollars, or it can be to the defendant who doesn't pay anything. Okay? After the arbitrator grants an award, the prevailing party can move to have the court confirm the award. That becomes a judgment. The opposing party may move to vacate the award, but motions to vacate and or appeal an award are granted on very limited bases, which we'll talk about in a minute. If the award is confirmed, it is final and binding and enforceable as a judgment. Okay? Let's talk about judicial review of an award. An arbitration award may be vacated even on appeal on narrow statutory grounds, such as fraud, illegality, or unconscionability. The partiality of the arbitrator, an arbitrator's refusal to delay proceedings for sufficient cause, not following the arbitration agreement to such a degree that it affects the outcome, and the award represents a manifest disregard of the law. But in order to do that, you have to show that the arbitrator knew the applicable law and disregarded it anyway. In order to get an award modified, you can get an award modified. It can be done so on motion of a party to correct a miscalculation, you know, like the numbers are wrong. To modify awards that exceed the scope of the arbitration agreement or to correct minor imperfections of form. Practice pointer. Most lawyers that I know today, experienced litigators, don't like to go to arbitration. Okay? As I said, arbitration, if you go to arbitration, you're basically giving up your right to appeal, because the only grounds upon which you can get it reversed are these technical grounds
that have nothing to do with the facts of the case. So there's no appeal on the merits of the decision, only on there's fraud or unconscionability in the agreement, things of that nature. More importantly, arbitration started out as an alternative dispute resolution device to speed things up and to make them less expensive than trial. There's now an organization called the AAA, the Arbitration Association of America. Okay, they do a lot of what?
Sounds ridiculous.
Okay. They do a lot of arbitrations, and a lot of the arbitration agreements that we just talked about. We'll talk about the reality of what they really are in a minute. Is named as the arbitration association or body that's going to conduct the arbitration. And then they have a whole bunch of people on their panel who are arbitrators, okay? Well, over the years, it's become more and more expensive to arbitrate through the AAA, okay?
Isn't the filing fee like $5,000 or $10,000?
Yes.
Yeah.
Yeah, I mean, it's a lot more expensive to file for arbitration with the AAA than it is to file for a jury trial in federal court or superior court, okay? And the arbitrators are asking for, you know, anywhere from $500 to $750 an hour.
Wow.
Okay? And they charge for everything. Make a phone call or charge. You send them an email or charge. Okay? So it's become very expensive. I just testified as an expert in an arbitration at the AAA in downtown LA, and they had put in over $100,000 in a case that was worth $20,000 to arbitrate this case. I mean, it's ridiculous. So for the reasons I just said, it's become really expensive. And you've basically given up your right to an appeal. You never know what's going to happen.
Aren't the arbitrators a lot less likely to award punitive damages too? Punitive damages, arbitrators are a lot less likely to award punitive damages.
Yes.
Is what I've heard, yeah.
Yeah.
And that's a lot of the times, it seems like anyways, I wouldn't know, but it seems like plaintiffs filing their cases, a lot of the times are just doing it for punitive damages.
Well, and I have no idea why anybody in a tort case would go to arbitration.
Yeah.
Okay, unless it's like a mass tort case, you know, where it's a class action and you wanna, for whatever your reason, you wanna shorten it. But more often than not, what was that, Aaron Brockovich? Anybody seen Aaron Brockovich, the movie? No? If we have time, I'll bring it in. This was a class action case. It was a mass tort. I think it was it groundwater pollution? There was some, I think it was groundwater pollution, at any rate. And, you know, there were hundreds of plaintiffs involved in this case. And they were suing, I don't know, PG&E or something like that, okay? And my law firm was involved in the defense of that case. And it went to arbitration, but the reason it went to arbitration was that PG&E wanted it to be confidential. They didn't want the facts of the case getting out. okay? And so there was like confidentiality agreement about whatever happens in this arbitration, it's not gonna come out. Okay? So that's one of the reasons that a defendant may want to go to arbitration. In my opinion, a lot of these big corporate defendants, especially hospitals, healthcare providers, insurance companies, have in their agreements arbitration clause. Kaiser Permanente has an arbitration clause, and they have their own arbitration procedures. Where you, if it goes to arbitration, they have their own arbitrators that hear these things. How fair do you think that's gonna be? Okay? So a lot of these big corporations that you probably signed arbitration clauses and didn't even.
And they're unfavorable to the consumer most of the time.
Yeah.
Like saying that if
You're giving up your right to a trial.
And if you lose the arbitration, then you have to pay the arbitration fees. But if you win, the corporation will not have to pay the arbitration fees.
That would be unconscionable.
Yeah.
We'll talk about that in a minute. But there were clauses like that. They've been ruled unconscionable. I mean, in California, they were found unconscionable, but we'll get to that in a minute. Okay, so the agreements that we're talking about, the arbitration agreements, are usually form agreements that are written by businesses, usually corporations, usually big corporations, national corporations, that in some way require you to sign an agreement. I wouldn't be surprised if your Spectrum agreement has an arbitration clause, right? Or DirecTV, or whatever you want for anything, probably has an arbitration clause. And why do they want to do it?
Because it's not much money to them.
That's right.
The appeal is going to work out in their favor, the lack of appeal. And then, like we talked about, no punitive damages really.
Well,
Very rarely.
but there are other issues. For example, they'll name like the Arbitration Association of the AAA, or JAMS is another one. JAMS is an ADR corporation that started in LA and has gone nationwide. And all the neutrals or arbitrators who serve on their panel, if you've got Kaiser or Blue Shield. I did an arbitration against Blue Shield. And in order to do this arbitration, their home office is in San Francisco. And they only, and in their agreement, it says if you wanna arbitrate with them in California, you gotta go to San Francisco. Okay, so my client could afford to go to San Francisco, and they could afford to simply go to San Francisco. Go to San Francisco, I'm arbitrating in front of this guy. I check him out before we go in there. He's a retired judge, and he's probably arbitrated a couple of 100 cases for Blue Shield. He's never going to see me again. Guess what? I mean, that's why they want to do arbitrations, because they get arbitrators who become essentially
Their employees almost.
Yeah, almost their employees, because they're making all this money off of them. So they may fine for the plaintiff, but the awards are going to be something that they think, the arbitrator thinks the corporation will be able to deal with.
Isn't it so they can discourage the person filing lawsuits, so people don't want to file lawsuits against them? So
Well, people will still file for arbitration, but the problem is, once they're stuck in arbitration, you know, a case that could, let's say a case that's, if you took it to trial in front of a jury, it might be worth $1 million on a tort, okay? You take it to arbitration, you know, maybe it's 250,000. Okay? And there's no appeal. So that's why most tort lawyers are not fans of arbitration. Okay? So let's move on here. Okay? There's this thing called 9 U.S.C. Section 2, the Federal Arbitration Act, or the FAA. It was enacted in 1925 to counter judicial hostility to pre-dispute arbitration agreements. The FAA compels judicial arbitration of a wide range of written agreements. Section 2 provides that arbitration agreements shall be valid, irrevocable, and enforceable. It also provides that federal courts should apply ordinary state law principles that govern the formation of contracts. We've got a bunch of cases here. I'm just going to give them to you quick, okay? Ask questions as we go along. There's just 4 cases. First one is Ferguson versus Countrywide Credit Industries. That's a 9th Circuit case. Ninth Circuit's us. This is a 2002 case. Misty Ferguson filed a complaint in California federal court against Countrywide Credit Industries and her supervisor under federal and California state laws alleging sexual harassment. Countrywide filed a petition for an order compelling arbitration. The district court denied the petition on the basis that Countrywide's arbitration agreement was unenforceable under Armendariz versus Foundation Healthcare Services, a California Supreme Court case. In Armendariz, the California Supreme Court provided a definitive pronouncement of California law on unconscionability to be applied to mandatory arbitration agreements. The court held, the Ninth Circuit held, that in Armendariz, the Supreme Court of California ruled that a mandatory arbitration contract is unenforceable under the doctrine of unconscionability, where there are both a procedural and substantive element of unconscionability. Procedural unconscionability focuses on 2 factors: oppression and surprise. Oppression exists from inequality of bargaining power. Surprise involves the terms of the agreement usually being hidden in the form, in a template by the party seeking to enforce the terms of the agreement. Substantive unconscionability focuses on the terms of the agreement and whether those terms are so one-sided as to shock the conscience. In this case, there was procedural unconscionability because the bargaining power of each party was unequal. The plaintiff had to sign the agreement in order to accept the terms of her job. There was substantive unconscionability because the terms were one-sided. The agreement compelled arbitration of plaintiff's claims, but exempted from arbitration the defendant's claims. Sound familiar? Supreme Court said that was invalid. Okay, unconstitutional. Okay, unconscionable. Went on to say defendant's agreement provision that it pay that plaintiffs pay a $125 filing fee and share equally in the cost of the arbitrator, imposes multiple fees which would bring the cost of the arbitration for the plaintiff in the multiple thousands of dollars. So the district court's denial of the defendant's petition to compel arbitration was affirmed. So no mandatory arbitration. Under Ferguson, those contracts are unconscionable. Those terms are unconscionable. Okay. Second one is AT&T versus Concepcion. This is a U.S. Supreme Court case, 2011. You guys know about AT&T?
Yes.
You know who they are. You know what this agreement's about. It's a cell phone agreement. Okay. Anybody here got AT&T?
There's actually a dispute going on at my work right now over, we signed up a bunch of like 480 lines, right, that we're gonna distribute. I work for a staffing company.
Yeah.
And they set it up like a family plan where they added one cell phone at a time. So there's 488 contracts and they all have arbitration agreements, and there was a bunch of fraud that's involved. And it kind of just happened over the last couple of years. So this is gonna be something that is litigated probably, if we can get it out of arbitration, probably a couple of years from now, because it just happened. But
Well, so the first thing you got to do is argue that the agreement's unconscionable.
unconscionable, yeah. I've been writing stuff down since we've been talking about it.
Okay, so these cases are in the book.
I know, that's what I'm.
Okay, so AT&T, you're not gonna like this one.
Oh, no. Don't tell me that.
Yeah, This is a Scalia decision. Okay, this was an agreement with AT&T for the sale and servicing of a cell phone. The contract provided for arbitration of all disputes between the parties and required that the claims be brought in the parties' individual capacity and not as class members. So in other words, it was getting rid of class actions. So each of you guys have to sue separately. In your case, that's not the case because you've got a family plan.
Yeah, really, it should have been set up as a corporate plan. And
Yeah, but it's probably cheaper to do a family plan. And if they allowed it,
they mismanaged, there was some mismanagement of the account on our part, but there was definitely a lot of mismanagement on their part. And there were a bunch of unauthorized charges, where they added apps and stuff like that.
Yeah.
And we're charging monthly. I mean, you got the bill, and the bill was like a book this thick every month.
oh,
$35,000 a month
oh my God.
for like 2 years.
That's crazy.
Yep.
Okay, so it required, okay. So the agreement allowed AT&T to make unilateral amendments, which it did to the arbitration provision on several occasions. The Concepcion's, the plaintiffs, filed a complaint in federal court, which was consolidated with a class action alleging fraud and false advertising. AT&T moved to compel individual arbitration pursuant to the agreement with the Concepcion's. You see the advantage of mandatory arbitration agreements for these large corporations? The district court, citing another California Supreme Court case, Discover Bank versus Superior Court, holding AT&T's arbitration agreement unconscionable, denied the motion on the ground that the agreement was unconscionable solely because it disallowed class-wide arbitration. That's an important fact. The Ninth Circuit affirmed, holding that Discover bank was not preempted by the FAA. Remember the FAA? The Federal Arbitration Act. Okay. The issue is, does the FAA preempt state law that prohibits contracts disallowing class action arbitration? Scalia wrote the opinion. Hello? All right, Scalia wrote the opinion. Who do you think he sided with?
AT&T.
Good guess. I don't know the last time Scalia sided with a consumer. Scalia wrote, the FAA preempts state law that prohibits contracts disallowing class action arbitration. In interpreting the FAA, he wrote, we have held that parties may agree to limit with whom a party will arbitrate its disputes. Okay. In this particular case, they held California Discover Bank, the ruling in that case interferes with arbitration. Although the rule does not require class-wide arbitrations, it allows any party to a consumer contract to demand it ex post. That means after the agreement has been consummated. The rule is limited to adhesion contracts, but the times in which consumer contracts are anything other than adhesive are long past. The rule also requires that, in other words, Scalia is saying adhesion contracts are okay. Why not? Right? This is the age of the corporation. The rule also requires that damages be predictably small and the consumer allege a scheme to cheat consumers. The former requirement, however, is toothless and malleable, he writes well. And the latter has no limiting effect, as all that is required is an allegation. Okay? Because it stands as an obstacle to the purposes and objectives of the FAA, California's Discover Bank rule is preempted by the FAA. The judgment of the Ninth Circuit is reversed. Now, that does not hold. That's a finding that the bank's case is an obstacle, okay? It does not reverse Ferguson versus Countrywide. So you've still got, as far as I know, Ferguson's holding in this district, in the Central District, and in the Ninth Circuit, that California's Almendarez versus Foundation Health ruling on unconscionability is the law. Okay? So you got to make sure that you distinguish between AT&T and Ferguson versus Countrywide. Now the problem becomes the next case, which is Ferguson versus Writers Guild of America. Because Ferguson's really an active person. Ferguson's all over the place. Different Ferguson. This is a California Court of Appeals case, 1991. This is, you know what the Writers Guild is, right? They're screenwriters.
Oh, yeah.
Okay? The Writers Guild. They write, you know, they write screenplays. The Guild gave Ferguson, a plaintiff, partial credit for writing the screenplay for Beverly Hills Cop 2. The Guild collective bargaining agreement provided for mandatory Guild arbitration. Anonymous arbitrators were chosen from a list of Guild members. Their decision was subject to appeal to the Guild's Policy Review Board. The board approval of a determination was final. Ferguson filed for Guild arbitration to have himself declared the sole screenwriter. He lost the arbitration and appeal to the Guild's Policy Review Board after the board declared the determination final. He filed a petition asking the Superior Court to determine that he was the sole screenwriter, or in the alternative, to order a new arbitration due to the Guild procedural improprieties and irregularities. The issues were twofold. One, does judicial review of an arbitration decision extend to the merits of the dispute? And two, was the arbitration a material and prejudicial departure from the procedures specified in the agreement? And the court held the scope of judicial review of arbitration decisions does not extend to the merits of the dispute. And that's what's important in this case. You cannot appeal on the basis that the court got the merits wrong. Okay? Only on the basis of procedure. Quote, the court does not review the merits of the arbitrator's award. It examines only whether the parties in fact agreed to submit their controversy to arbitration, whether the procedures employed deprived the objecting party of a fair opportunity to be heard, and whether the arbitrators exceeded their powers. That's it. In this particular case, they said that judicial review of arbitration procedures is restricted to whether a party challenging the determination has demonstrated a material and prejudicial departure from the procedure specified in the agreement, and they said they didn't. Those procedures, there's nothing unconscionable about the procedures, and they didn't deviate. End of story. See why arbitrations, it's problematic. Okay? Now, that's arbitration by agreement, okay? Contractual or judicial arbitration. I'm sorry, by contract. There's such a thing as judicial arbitration. That's 128 USC versus section 654. I'm losing it. California has something similar to this, okay? In both federal and state courts, a judge may order arbitration by a neutral, which may be either binding or non-binding. If the court order is for non-binding arbitration, which is most common, a party may request a trial de novo, and the lawsuit will proceed as though there has been no arbitration. We used to do that in the Superior Court in Los Angeles